Have you ever wondered what really happens after the police file a report for a serious crime? I mean, what's the actual process in court? Well, today we're going to break down the entire procedure for what the law calls warrant cases. We're going to follow the whole journey step by step from the initial accusation all the way to the final verdict. So, let's start with the big question right up front. When the police charge someone with a serious offense, what's the actual path that case takes? How does our legal system make sure everything is fair and above board? Let's find out. First off, it's really important to know that not all criminal cases are handled the same way. You can think of it like two different tracks. On one track, you have summon cases. These are for less serious offenses, and the procedure is, a bit simpler. But for the serious crimes, we have warrant cases. These follow a much more detailed and strict process. And that's the journey we're exploring today. So here's our game plan. We'll start with a quick intro to what these cases are, then look at the crucial steps that happen before the trial even kicks off. After that, we'll see how the charge and the plea work, dive into the main event, the battle of evidence, and finally see how it all wraps up with a verdict. Let's get started. All right, let's jump right in. Before we get into the nitty-gritty, we need to understand the specific framework we're talking about, because in law, the details really do matter. So we are zeroing in on a very specific type of case, a warrant case that starts because the police filed a report. And this is a super important detail, because the law lays out a very specific set of rules for how a magistrate has to handle things in this exact situation. Now, before you even get to what most people think of as a trial, with witnesses and everything, the court has to take care of two really crucial preliminary steps. These are all about making sure the accused starts on a level playing field. Okay, so here they are, the two big foundational steps. First up, under Section 230, the court has to make absolutely sure the accused gets all the important documents. Then there's this really critical review under Section 262, and this step could actually stop the case right in its tracks. So think of Section 230 as the no surprises rule. The whole point is to make sure the accused and their lawyer get a complete file of everything the prosecution has against them, and it's all free of charge. This means the police report, the original FIR, all the witness statements, everything. It's all about fairness from the get-go. Now for Section 262. This part is fascinating. It acts like a quality filter for the justice system. After looking at all those documents and hearing from both the prosecution and the defense, if the magistrate looks at the case and thinks, you know what, this is completely groundless, they have to discharge the accused. This is huge. It prevents people from being dragged through a full trial on a flimsy or baseless accusation. But what does groundless actually mean here? Well, the Supreme Court cleared this up in the Shoraj Singh Alawat case. They said the bar for discharging someone is pretty high. The prosecution doesn't have to prove guilt at this early stage. If the evidence creates a strong suspicion that a crime was committed, then the trial has to proceed. Okay, so let's say the case isn't dismissed. What's next? Well, now we move into the courtroom, and the trial officially kicks off with something called framing of the charge. Under Section 263, the magistrate makes the accusation official. A formal written charge is created that spells out the exact crime the person is accused of. And this isn't just paperwork. It is then read aloud and explained to the accused to make 100% sure they know exactly what they're up against. And at this moment, the ball is officially in the accused's court. They've heard the charge, they understand it, now they have to respond. And their answer is going to set the course for the rest of the entire trial. So what can they do? So the accused comes to this critical fork in the road. Path number one, they can plead guilty, which is handled under Section 264. Or path number two, they can claim trial, which basically means they deny the charge and are saying to the prosecution, okay, prove it. Now, if the accused pleads guilty, the magistrate can convict them right then and there. But, and this is a big but, it's not automatic. The judge has to be totally satisfied that the person understands what they're admitting to and what the consequences are. There was a famous case back in 1950, Syed Usman, that showed a court won't convict if the facts a person admits to don't actually amount to a crime under the law. So if the accused says not guilty and claims trial, we enter the absolute heart of the legal process. This is the main event. It becomes a battle of evidence, with the prosecution and the defense each getting their chance to make their case. As laid out in Section 265, the prosecution gets to go first. They're the ones who have to prove their case. So they present all their evidence, call their witnesses, and try to build their argument. And for every witness they call, the defense gets a critical chance to question them in what's called cross-examination. And then the tables turn. Under Section 266, it's the defense's turn. The accused gets to present their side of the story. They can submit a written statement, and they can call their own witnesses and present their own evidence to poke holes in the prosecution's case and build an argument for their innocence. All right, so after all the evidence has been shown, all the witnesses have spoken, and both sides have made their arguments, we finally reach the last stop on this journey, the judgment. Section 271 covers this final phase. Both the prosecution and the defense give their closing arguments, where they basically summarize their entire case. The magistrate then has to consider everything, every piece of testimony, every document, every argument, to make a final decision. In the end, it all comes down to one of two outcomes. First, acquittal. This means the magistrate finds the accused not guilty and they are free to go. Or second, conviction. This means the magistrate finds them guilty. If that happens, the process isn't over. There's then a separate hearing to decide on the proper punishment or sentence. And there you have it. That is the complete journey of a warrant case trial, from that initial police report all the way to the final verdict. Every single step is carefully designed to create a structured and fair process. So the last thing to think about is this: how well does this whole meticulous system actually work to balance the rights of the accused with the pursuit of true justice?